I was at home folding laundry when my phone started buzzing like crazy. Text after text. Notification after notification. I grabbed it, confused, and opened my email. There it was. A message sent to every single person at MedSource Solutions. 340 employees. Clients. Vendors. Everyone. My photo stared back at me from the screen, and underneath in bold letters. Fired for leaving 2 minutes early. Do not rehire. My hands shook. The sender was Patricia Walsh, our HR director. Within minutes, my phone rang. My mother. Then, my best friend. Then, former colleagues from other companies. They had all seen it. My career was being destroyed in real time, and I could do nothing but watch. I couldn't breathe. I stared at that email for what felt like an hour but was probably only 5 minutes. My brain tried to process what was happening. This had to be a mistake. Some terrible, awful mistake that could be fixed with a simple phone call. I dialed MedSource's main line with trembling fingers. The receptionist transferred me to HR. Roger, Patricia's assistant, answered in his usual monotone voice. I need to speak with Patricia immediately, I said, trying to keep my voice steady. There's been a huge mistake. That email she sent about me. Miss Walsh is unavailable, Roger replied. She's in meetings all afternoon. Roger, please. This is urgent. She sent an email to the entire company saying I was fired for leaving 2 minutes early. I left early on Friday to make it to federal jury duty. I have the summons. I submitted it to HR 2 weeks ago. There was a pause. I'll pass along your message. He hung up. I immediately opened my laptop and started drafting an email to Patricia, copying HR and my supervisor, Brad Hennigan. I attached a scan of my federal jury summons. The document was official, stamped by the courthouse, requiring my appearance at 5 o'clock on Friday for grand jury orientation. I had left work at 4:58 that day, 2 minutes before 5. I'd practically run to my car to make it downtown in time. My email was professional, clear, and desperate. I explained everything. I apologized for any confusion. I asked for the company-wide email to be retracted and corrected. I hit send and waited. Within an hour, my phone buzzed with a new email notification. My stomach dropped when I saw it was another company-wide message from Patricia. The subject line read, "Regarding previous termination notice." I opened it, hopeful that this was the retraction. It wasn't. Patricia's email stated that I was fabricating excuses and displaying dishonesty in an attempt to avoid accountability. She claimed that no jury summons had ever been received by the HR department. She included a screenshot of what she called official HR records, showing no documentation on file for me regarding jury service. The email concluded by saying that attempts to mislead the company further demonstrated why my termination was justified. I felt sick. How could she say no documentation was received? I had physically handed a copy to the front desk with instructions to deliver it to HR. I had followed up with an email. I remembered doing it. My phone rang. Brad Hennigan, my boss, the VP of Finance. We'd worked together for 3 years. He'd always been supportive, friendly even. He'd written my last performance review, calling me an invaluable asset to the department. Brad, thank God, I answered. Did you see Patricia's emails? This is insane. I have proof that I submitted that jury summons. I can show you right now, Lori. His voice was cold, distant, nothing like the Brad I knew. Patricia showed me some concerning evidence this afternoon. Evidence? What evidence? Your time card records. You've been leaving early regularly, 6 times over the past 2 months. What? Brad, those were all approved. I had a dentist appointment. I had that emergency when my apartment flooded. And the jury duty. You knew about all of those. I have no record of you informing me about jury duty. And as for the other instances, you should have submitted formal leave requests through the system. You didn't. But I told you about them. You said it was fine. You told me to just make up the time. Lori, I think you're misremembering. Patricia has documented everything. She's been tracking these violations for weeks. I'm sorry, but the termination stands. I have to go. He hung up before I could respond. I sat there, phone in hand, trying to understand what had just happened. Brad had turned on me completely. He was acting like he'd never approved any of those early departures. Like I'd been sneaking out without permission. I tried logging into my work email to find the messages where I'd told Brad about my appointments. Access denied. My account was already deactivated. I tried the company portal. Same thing. Locked out. My LinkedIn profile showed 17 new views in the past hour. All people from my industry. The email was spreading beyond MedSource. People were seeing it. Judging me. A recruiter I'd spoken with last month about a potential opportunity sent me a brief message. Hi Lori, we've decided to move forward with other candidates. Best of luck. The email had poisoned everything. I got up and searched through my home file cabinet, pulling out every document related to my job. There it was. My copy of the federal jury summons. I took a photo of it with my phone, documenting the date, the requirement to appear, everything. I called the company's compliance hotline. It rang 3 times before someone picked up. Compliance and Ethics Hotline. How may I help you? I need to file a complaint about an HR decision. I was wrongfully terminated and I need someone to review what happened. One moment, I'll transfer you to the appropriate department. The hold music played for 30 seconds. Then someone picked up. Human Resources. This is Roger speaking. My heart sank. The compliance hotline routed to HR, to Patricia's assistant. Roger, this is Lori again. The compliance hotline just transferred me to you. That doesn't seem right. I'm trying to file a complaint about HR. All complaints regarding HR decisions are reviewed by the HR department, he said in that same flat tone. We have a process for internal appeals. I can send you the form. But how can HR investigate itself? That's a conflict of interest. It's company policy. Would you like me to send you the form or not? I hung up without answering. I opened my laptop and searched online for advice. I found a legal forum and posted anonymously, explaining my situation. Within 20 minutes, several people had responded. Document everything. Get a lawyer. This could be wrongful termination. Some asked if I'd been discriminating against or retaliated against for some reason. That word stuck in my head. Retaliation. But for what? I'd never reported anything. I'd never caused problems. I was a good employee. Everyone said so. My phone buzzed again. Another LinkedIn view. Then another. Then a message from someone I didn't know. Saw what happened at MedSource. Rough situation. Good luck. Strangers were watching my professional reputation crumble in real time. I didn't sleep that night. Every time I closed my eyes, I saw that email. My face. Those words. By morning, I'd received texts from 7 different people, all asking if I was okay, all having heard about what happened. The apartment felt suffocating. I needed to get out, to think, to figure out what to do next. But then I heard keys in the lock. Trevor came through the door. My fiancé. We'd been together for 4 years, engaged for 6 months. He worked at a marketing firm downtown. He should have been at work. Why are you home? I asked. He set his bag down heavily. We need to talk. My stomach twisted. What's wrong? Someone at my office forwarded me that email. About you getting fired. He wouldn't look at me. People are asking me about it. It's embarrassing. Lori? Embarrassing? Trevor. I'm the one who was publicly humiliated. I didn't do anything wrong. I left 2 minutes early. For jury duty. Then why would HR send that email? Why would they do that if you didn't deserve it? I stared at him. You don't believe me. He finally looked up. I'm just saying. There has to be more to the story. Companies don't just fire people and send emails like that for no reason. I have the jury summons right here. I grabbed it from the table. See? Federal grand jury. Required by law to attend. I submitted this to HR 2 weeks ago. He glanced at it. Maybe you forgot to submit it properly. Or maybe you thought you did but didn't. Trevor, I'm not crazy. I submitted it. They're lying about not receiving it. He sighed, running his hand through his hair. This is exactly like what happened at your last job. I felt like I'd been slapped. What? At your last company? You said they retaliated against you for reporting something. You said they made your life difficult until you left. Maybe the problem isn't them. Maybe it's you. I couldn't believe what I was hearing. I reported safety violations in the manufacturing process. That was the right thing to do. And yes, they retaliated. That's why I left. Or maybe you just don't follow the rules, Lori. Maybe you cause problems, and then act surprised when there are consequences. Tears burned in my eyes. I can't believe you're saying this. He stood up. I need some space. I'm going to stay at my brother's place for a while. Space? Trevor, we're supposed to be getting married. I know, but I need time to think. This is a lot. He grabbed some clothes from the bedroom and left. Just like that. The person who was supposed to support me, who was supposed to believe in me, walked out because I'd been fired. I called my mother. She answered on the third ring. Lori, sweetie, I saw your messages. What on earth is going on? I explained everything through tears. The jury duty. The email. Patricia's lies. Brad turning on me. Trevor leaving. My mother listened, then said quietly, Honey, why would they do this? What aren't you telling me? Mom, I'm telling you everything, there's nothing else. It just doesn't make sense. People don't get fired for leaving 2 minutes early. There must be something more. Even my own mother doubted me. We talked for a few more minutes before she had to go. I sat alone in the apartment. Feeling like the walls were closing in, I forced myself to focus. I needed a job. I needed income. I opened my laptop and started applying to every pharmaceutical company in the area. I had 10 years of experience in financial analysis. Good credentials, strong references, or at least, I'd had strong references. I submitted 5 applications in 2 days. 4 came back with immediate rejections. Form letters. Thank you for your interest, but we've decided to move forward with other candidates. The 5th company called me in for an interview. Jessica Carlson, the hiring manager at a competitor company called PharmaCore, seemed friendly on the phone. The position was perfect for my skill set. I dressed carefully for the interview, prepared my answers, brought copies of my resume. The interview started well. Jessica asked about my experience, my approach to financial forecasting, my knowledge of pharmaceutical regulations. I answered confidently. We talked for 20 minutes, and I could tell she was impressed. Then her phone rang. Excuse me one moment, she said, stepping into the hallway. I waited, reviewing my notes. 5 minutes passed. Then 10. When Jessica came back, everything had changed. Her expression was cold, closed off. I'm sorry, Lori. We've decided to move forward with other candidates. What? But we were just discussing the position. Yes. Well, we received some information that concerns us. My heart sank. About MedSource? She didn't answer directly. We need someone with a proven track record of reliability and professionalism. I have that. I have 10 years of excellent performance reviews. I'm sorry. The decision is final. She stood up, clearly ending the interview. I left the building feeling numb. They'd called MedSource. Someone there had poisoned this opportunity too. That evening, I contacted Amy, a former colleague who still worked at MedSource in the accounting department. We'd been friendly, had lunch together sometimes. I sent her a careful text asking if she'd talk to me. She called me from her car, speaking in whispers. Lori, I can't talk long. I'm sorry about what happened. Amy, what's going on there? Why did Patricia do this? She's been calling companies. Other pharmaceutical firms. I overheard her on the phone yesterday. She's telling them you were terminated for cause, and that you're threatening to sue. She's saying you're difficult to work with. Litigious. What? I haven't threatened anything. I haven't even hired a lawyer. I know, but that's what she's telling people. It's like a campaign. She's making sure you can't get hired anywhere in the industry. Why would she do that? Amy was quiet for a moment. I don't know. But Lori, I can't help you. I can't be involved in this. If anyone finds out I talked to you, I could be next. I'm sorry. She hung up. I checked my bank account. I had enough money to cover 1 month of expenses. Maybe 2 if I stretched it. The apartment lease was in both my name and Trevor's. He'd already sent me a text saying he wasn't going to pay his half of the rent anymore. I called the landlord and explained the situation. He was sympathetic but firm. The lease was a legal contract. If the full rent wasn't paid, we'd both be liable. Eviction proceedings would start after 30 days. I tried to find a temporary job, retail, food service, anything. But every manager I spoke with asked for my previous employment. When I mentioned MedSource, I could see the recognition in their eyes. Some of them had seen the email. One retail manager at a department store told me directly, "We can't hire you. It's a liability. If your former employer felt strongly enough to send that kind of email, there must be serious issues." I was being erased from the workforce. Systematically, deliberately. My phone buzzed with another notification. Another LinkedIn view. Someone from a company I'd applied to 3 days ago. They were checking me out. Probably reading about MedSource. Probably deciding not to hire me. I sat on the couch in my apartment, my engagement ring still on my finger, wondering how my entire life had fallen apart in less than a week. 10 days after the email, I received a certified letter. I signed for it at my apartment door, my hands shaking as I opened the envelope. It was from Keller and Associates, attorneys at law, representing MedSource Solutions. The letter demanded that I sign an enclosed, non-disclosure agreement and release of claims form within 48 hours. The document stated that I would not disparage MedSource, would not discuss my termination with anyone, and would release the company from any legal liability related to my employment or its termination. If I didn't sign, the letter said, MedSource would pursue legal action against me for violating confidentiality clauses in my original employment agreement. I pulled out my old employment contract and read through it frantically. There was a confidentiality clause, but it was vague. Something about not sharing proprietary business information or trade secrets. I'd never shared anything like that. But the language was broad enough that a good lawyer could probably twist it to mean almost anything. I couldn't afford a lawyer. I could barely afford groceries. I stared at the NDA. If I signed it, this would all go away. I could try to move on, find a job in another industry, start over. But signing felt like admitting I'd done something wrong, like letting them win. My phone rang. Unknown number. I almost didn't answer, but something made me pick up. Is this Lori? A man's voice. Professional and official. Yes, who is this? This is Agent Dennis Kovac, with the Federal Bureau of Investigation. I'm the coordinator for the grand jury you were selected to serve on. You missed the last 2 sessions. Is everything all right? I felt tears well up. Someone official, someone who might actually help. Agent Kovac, I'm so sorry. I was fired from my job. The email they sent, the whole situation. It's been overwhelming. I couldn't focus on anything. Fired? When did this happen? The Friday of orientation. I left work 2 minutes early to make it to the courthouse by 5. The next day, my company sent an email to everyone saying I was fired for leaving early. They're claiming I never submitted my jury summons to HR, but I did. I have proof. There was a pause. They fired you for attending jury duty? That's what it looks like, yes. Miss Lori, that's a federal violation. Retaliation against an employee for jury service is explicitly prohibited under federal law. Title 28, United States Code, Section 1875. Hope surged in my chest. So I can fight this? You absolutely can. And I'd like to help. Would you be willing to meet with me tomorrow? I'd like to review the documentation and potentially speak with your former employer. Yes, absolutely. Thank you. We arranged to meet the next morning at a coffee shop. I spent the rest of the day organizing every document I had: the jury summons, my employment contract, copies of emails, screenshots of the company-wide messages. Everything. That night, I barely slept again. But this time, it wasn't from despair. It was from hope. A federal agent was getting involved. MedSource couldn't push around the FBI. The next morning, Agent Kovac was exactly on time. He was in his 50s, professional, with sharp eyes that took in every detail. We sat at a corner table, and I showed him everything. He reviewed each document carefully. This is very clear. You submitted proper documentation. They terminated you immediately after you exercised your federal right to serve on a grand jury. That's textbook retaliation. What can we do? I'd like to visit MedSource's office and speak with their HR department. Review their records. With your permission, I'll make this an official inquiry. You have my permission, please. He made some notes. Then he looked up at me with an expression I couldn't quite read. Lori, I need to tell you something. The grand jury you were serving on was investigating MedSource Solutions for Medicare fraud. Did you know that? My stomach dropped. What? No, I had no idea. Grand jury proceedings are confidential. You were randomly selected from the jury pool. But now that I know they fired you immediately after you were sworn in, this takes on a different significance. You think they knew? That they fired me because of the investigation? I don't know yet. But I'm going to find out. We arranged to meet at MedSource's office the following afternoon. Agent Kovac would show up as an official federal representative investigating potential jury tampering and retaliation. I felt like I could breathe for the first time in 2 weeks. The next day, I met Agent Kovac in the parking lot of MedSource. The building looked the same as always. Glass and steel, modern and clean. I'd walked through those doors every day for 3 years. Now I was walking in with a federal agent. The receptionist's eyes widened when she saw me. She made a quick phone call, then directed us to the third-floor boardroom. Patricia Walsh was already there. So was Brad Hennigan. And a man in an expensive suit I'd never seen before. Miss Lori, Agent Kovac, the suited man said, standing to shake our hands. I'm Donald Pierce, General Counsel for MedSource Solutions. I understand there are some concerns about Miss Lori's termination? We all sat down. The room felt cold despite the afternoon sun coming through the windows. Agent Kovac placed his briefcase on the table. I'm here because Miss Lori was terminated from employment on the same day she was required to appear for federal grand jury service. Retaliation against an employee for jury service violates federal law. Patricia folded her hands calmly. Agent Kovac, I appreciate your concern, but there's been a misunderstanding. Miss Lori was not terminated for jury service. She was terminated for a pattern of unauthorized absences and violations of company policy. Do you have documentation of her jury summons on file? Patricia produced a folder perfectly organized. This is Miss Lori's personnel file. As you can see, there's no record of any jury summons being submitted to Human Resources. Agent Kovac didn't miss a beat. I have confirmation from the courthouse that MedSource Solutions was officially notified of Miss Lori's jury obligation. The notification was sent by certified mail to your HR department 3 weeks before the orientation date. Patricia's expression didn't change. We never received such notification. Perhaps it was sent to an incorrect address. Donald Pierce leaned forward. Agent Kovac, even if there was a communication error, MedSource has every right to terminate an employee for leaving work without proper authorization. Miss Lori left her post 2 minutes before the end of her shift without notifying her supervisor. I did notify him, I said. I told Brad 2 weeks before. Brad spoke up, his voice even. I have no record of that conversation, Lori. If you had told me about jury duty, I would have approved it and documented it properly. But I did tell you. I sent you an email. I've reviewed my email records, Brad said. There's nothing from you about jury duty. Agent Kovac requested to see the time card records. Patricia produced them immediately. 6 instances over 2 months where I'd left before 5 o'clock. But there was no context. No notes about why. No approval codes. Miss Lori had a pattern of leaving early without authorization, Patricia said. The incident on Friday was simply the final occurrence that led to termination. Agent Kovac opened his binder. He found the specific statute and read aloud. An employer shall not deprive an employee of employment, or threaten or otherwise coerce said employee, with respect thereto, because such employee or person served as a juror. The room was silent. Then Donald Pierce changed tactics completely. He produced a new document from his own folder. Agent Kovac, I appreciate your concern for Miss Lori, but I need to make you aware of something. 3 days ago, Miss Lori came to this office and threatened HR staff. Specifically, she told Miss Walsh that she had connections with federal agents and would make sure we regretted her termination. My mouth fell open. That never happened. I never came here. I never said that. Patricia's voice was calm, almost sympathetic. Lori, I understand you're upset, but making threats won't help your situation. Roger was present when you made those statements. He witnessed everything. From the corner of the room, Roger nodded. I was there. She said she knew people in federal law enforcement. That's a complete lie. I turned to Agent Kovac. I never came here. I never threatened anyone. This is the first time I've been in this building since I was fired. Donald Pierce looked at Agent Kovac with concern. I'm troubled by your involvement here, Agent Kovac. Miss Lori clearly has been leveraging her connection with you to intimidate our staff. That raises questions about the propriety of your relationship with a grand jury member. Agent Kovac's jaw tightened. I met Miss Lori for the first time yesterday when she explained why she'd missed jury sessions. But she knew to call you. She knew you'd help her. That suggests a pre-existing relationship. Donald pulled out another document. I'm prepared to file a formal complaint with the FBI about potential improper conduct. A federal agent inserting himself into a private employment dispute, possibly at the request of someone with whom he has an undisclosed relationship, is highly irregular. I couldn't believe what was happening. They were turning Agent Kovac's help into something suspicious. They were making it look like I'd manipulated a federal agent. Agent Kovac stood. Mr. Pierce, I'm here in my official capacity investigating potential witness intimidation and jury tampering. Your threats don't concern me. They're not threats, Agent Kovac. They're legitimate concerns about procedure and ethics. I suggest you consult with your supervisors before proceeding further with this matter. The meeting ended badly. Donald demanded we leave the premises. Patricia and Brad sat there looking calm and professional, while I felt like I was drowning. In the parking lot, Agent Kovac said quietly, they were ready for this. They had their story prepared. What do we do now? I'm going to document everything and submit a report. But I need to be honest with you, Lori. They're good. They've created a counter-narrative that makes you look like the aggressor. And they're threatening to file ethics complaints against me. Which means my superiors are going to scrutinize every move I make on this case. So they win? I didn't say that, but this is going to be harder than I thought. He got in his car and drove away, leaving me standing in the parking lot of the company that was systematically destroying my life. 3 days later, a process server knocked on my apartment door. I was being sued. MedSource Solutions v. Lori Thompson. The complaint was 30 pages long, filed in county court, seeking $500,000 in damages. They were suing me for defamation. The lawsuit claimed I had posted false and malicious information about MedSource on public forums, damaging the company's reputation and interfering with their business relationships. They cited my anonymous post on that legal advice website. Somehow, they'd traced it back to me. Maybe through my IP address. Maybe through digital forensics. The complaint included screenshots of the post with metadata showing it came from my computer. I felt like I was going to be sick. I called every legal aid office in the area. None of them handled employment disputes against large corporations. They didn't have the resources. One paralegal suggested I try to find a lawyer who would work on contingency, but warned me that most wouldn't take a case against a company as big as MedSource. I finally found a lawyer willing to give me a free consultation. Gary Preston had a small practice focused on employment law. His office was in a converted house on the edge of downtown. The furniture was old but clean. Law books lined the walls. He reviewed the lawsuit while I sat across from his desk, trying not to cry. "This is a slap suit," he said after 20 minutes. "Strategic lawsuit against public participation. It's designed to silence you through legal intimidation. The goal isn't necessarily to win. The goal is to drain your resources and make you too afraid to fight back. Can I fight it? You can. But it's expensive. With discovery, depositions, motions, trial preparation, you're looking at $60,000 to $80,000 minimum. Probably more. I didn't have $60 to spare, let alone $60,000. What if I represent myself?" Gary sighed. "You could try. Some people do. But you'd be going against a team of corporate attorneys who do this for a living. The procedural requirements alone are complex. One mistake, and your case gets dismissed. What if I settle? That's what they want. They'll probably offer you a deal. You sign an NDA. Admit no wrongdoing. Agree never to discuss your employment or termination. In exchange, they drop the suit. But that means they win. They destroy my reputation and then silence me. Yes." Gary looked at me with sympathy. "I'm sorry. I wish I could help. But without a retainer, I can't afford to take on MedSource. They'll bury me in paperwork just like they'll bury you." I left his office feeling hopeless. Over the next week, I tried to file a response to the lawsuit on my own. I spent 12 hours in the public library, reading about civil procedure and employment law. I drafted a response by hand because I couldn't afford legal software. I argued that I was wrongfully terminated in violation of federal jury protection laws. I argued that the anonymous forum post was protected speech. I argued that MedSource had defamed me by sending that company-wide email. When I tried to file my response at the courthouse, the clerk reviewed it and looked sympathetic. "This is missing several required elements. The formatting isn't correct. You need to file a separate counterclaim if you want to sue them back." She couldn't help me with legal strategy, but she gave me pamphlets about pro se representation. I revised my filing and resubmitted it. It was accepted, but barely. Meanwhile, MedSource's legal team filed motion after motion. They requested all my emails, text messages, and financial records as part of discovery. They filed a motion to expedite the trial. They filed a motion for summary judgment, arguing that my case had no merit and should be dismissed before trial. I spent every day trying to keep up with the paperwork. Every night, I fell into bed exhausted, my eyes burning from reading legal documents. My first court appearance was a preliminary hearing. I walked into the courtroom in my only suit, carrying a folder of documents. Donald Pierce sat at the plaintiff's table with two associate attorneys. They had rolling briefcases filled with indexed binders. The judge asked me to present my defense. I stood up, my hands shaking, and tried to explain about the jury duty and the federal protection laws. Donald countered smoothly. He presented affidavits from Patricia and Roger, describing my supposed threatening behavior. He showed the time card records, suggesting a pattern of policy violations. He argued that I was a disgruntled former employee making false accusations. The judge asked me where my proof was. "Do you have documentation showing you submitted the jury summons to the company?" "I have my home copy, Your Honor," But I can't prove they received it because they claim they didn't. That's insufficient. Without proof of receipt, I can't conclude they knew about your jury service. The judge ruled the case would proceed to trial. My motion to dismiss was denied. Trial was set for 6 weeks out. Outside the courtroom, Donald approached me with a smile that didn't reach his eyes. "Miss Thompson, my client is prepared to make you a settlement offer. You drop all claims against MedSource. You sign a confidentiality agreement, and you pay $20,000 to cover our legal fees so far. In exchange, we drop our defamation suit. I don't have $20,000. Then I suggest you find it. Because at trial, we're seeking the full $500,000. Think about it." He walked away, leaving me trembling in the courthouse hallway. That night, I found an eviction notice taped to my apartment door. I was 30 days behind on rent. I had 14 days to pay or vacate. I called Trevor, desperate. "Please, I just need help with the security deposit." "You're on the lease. You're legally responsible too." "I talked to a lawyer," he said. "If you can't pay, that's your problem." I moved out. My name might be on the lease, but I'm not living there. "Trevor, please. I can't help you, Lori. You need to figure this out yourself." He hung up. I applied for unemployment benefits. The application asked why I'd been terminated. I explained about the jury duty. 2 weeks later, I received a denial letter. MedSource had contested my claim, stating I was fired for cause due to policy violations. The state believed them. My credit cards were maxed out. I'd been using them to pay for court filing fees, document copying, and basic living expenses. Collection calls started coming in. Natalie, my best friend, came over one evening and was horrified by what she saw. I'd lost 15 pounds. I wasn't sleeping. I hadn't been eating properly. "You're going to make yourself sick," she said. "Come stay with me. At least temporarily. I can't ask you to do that." "You're not asking. I'm insisting. Pack a bag. You're coming home with me tonight." I moved into Natalie's spare bedroom with one suitcase of clothes and my laptop. Everything else went into storage that I couldn't afford, but had no choice about. 3 days later, Agent Kovac called me. "Lori, I need to tell you something. The grand jury investigation into MedSource is being closed." My heart sank. "What? Why?" "I've been reassigned to a different case. A new agent, Linda Moreno, is taking over the MedSource investigation. She reviewed the evidence and determined there's insufficient basis to proceed with Medicare fraud charges." "But what about the jury tampering? The retaliation? That's being closed too." "The official determination is that there's no clear evidence MedSource knew you were on the grand jury investigating them. Your selection was random from the jury pool. Without proof they knew, we can't prove retaliation related to the investigation." "This doesn't make sense. Why now? Why is everything suddenly being shut down?" Agent Kovac was quiet for a moment. "Off the record? I think there's pressure coming from above. MedSource has connections, political donations. Their CEO, Charles Whitmore, contributed heavily to the governor's recent campaign. The governor appointed our U.S. attorney. Sometimes cases get closed for reasons that have nothing to do with the evidence, so they're untouchable." "I didn't say that. But they're powerful, and they know how to work the system." After he hung up, I sat on Natalie's couch and cried. The federal investigation was closed. I was being sued. I was facing eviction. My fiancé had abandoned me. My own family doubted me. I had no job, no money, and no way to fight back. That night, my mother called. She'd been talking to Trevor. "Sweetie, Trevor says you're not letting this go. He says you're obsessing over the MedSource situation. Mom, they're suing me for $500,000. I can't just let it go. Maybe you should settle. Sign whatever they want you to sign and move on with your life. They want me to pay them $20,000 and admit I lied. Well, maybe it's worth it to make this stop. You're destroying yourself over this." Even my mother thought I should give up. I hung up feeling more alone than I'd ever felt in my life. 4 weeks before trial, I received a call from Agent Linda Moreno, the new FBI agent assigned to what remained of the MedSource case. Her voice was cold and professional. "Miss Thompson, I'm calling to inform you that the grand jury investigation into MedSource Solutions has been officially closed. There will be no charges filed. Agent Kovac told me it was being reviewed. But closed completely? Correct. After thorough review, we've determined there's insufficient evidence to proceed. What about the jury tampering? The retaliation? We found no evidence that MedSource knew you were serving on a grand jury investigating their company. Your selection was random. Without that knowledge, there's no tampering. But they fired me for going to jury duty. That's still illegal. That's a civil matter, Miss Thompson, not a federal criminal matter. I suggest you pursue it through your lawsuit." She hung up. I sat there holding the phone, trying to process what had happened. The entire federal investigation was dead. My last hope for external validation was gone. I started researching MedSource's leadership. Charles Whitmore, the CEO, had donated $250,000 to Governor Patterson's campaign last year. Governor Patterson had appointed U.S. Attorney Rachel Chen to oversee federal prosecutions in our district. U.S. Attorney Chen's office had just closed the investigation into one of the governor's biggest donors. The connections were clear. The corruption was obvious. But I couldn't prove anything. I considered giving up entirely, just signing whatever MedSource wanted, walking away, starting over somewhere else with a new name and a new career. But that night, I was going through the discovery documents MedSource had provided as part of the lawsuit. Hundreds of pages of employee records, policy manuals, time card reports. It was overwhelming. Most of it seemed irrelevant. Then I noticed something in the time card records. Other employees had similar notations to mine. Unauthorized early departure marked next to their names. I started cross-referencing the names with LinkedIn. 3 of them no longer worked at MedSource. I tracked them down through social media and sent careful messages explaining who I was and what had happened to me. The first person to respond was Diane Foster. She'd worked in accounting until 8 months ago. We talked on the phone the next evening. "Oh my God," Diane said when I explained my situation. "The exact same thing happened to me." "What do you mean?" "I left work 30 minutes early one day to pick up my daughter from school. She was sick. The nurse called me. I told my supervisor and left. The next day, Patricia Walsh sent a company-wide email with my photo saying I was fired for abandoning my post. It said, "Do not rehire." Right there for everyone to see. My heart was pounding. Then what happened? I tried to fight it. I couldn't afford a lawyer. They threatened to sue me. Eventually I settled. I signed an NDA and moved to another state. I couldn't get hired anywhere around here, but I kept copies of everything. I violated the NDA, but I kept copies anyway. Would you be willing to share them with me? There was a long pause. I don't know. If they find out I violated the NDA, they'll sue me. I have 2 kids to support. I understand. But Diane, they're still doing this. They did it to me. They're probably going to do it to someone else. Let me think about it. The second former employee was Tom Brennan, who'd worked in IT until a year ago. Tom's story was similar. He'd left early to attend his father's funeral. The next day, Patricia sent the same kind of humiliating company-wide email. Tom didn't fight it. He was too devastated by his father's death. But he confirmed Patricia Walsh was the one who'd orchestrated everything. "She's done this before?" he asked, when I told him about Diane and myself. "It looks like a pattern." "That's sick. She destroyed my reputation when my dad had just died. I couldn't even grieve properly because I was dealing with that mess. Would you be willing to testify? Or provide a statement?" Tom was quiet. "I don't know, man. I've moved on. I don't want to relive that time." The third former employee was Sharon Ellis, who'd worked in quality control until 6 months ago. Sharon's story was almost identical. She'd left early to vote in a local election. Company-wide humiliation email the next day. Legal threats. Blacklisting in the industry. But Sharon was different from the others. "I tried to sue them," she said. I filed a wrongful termination lawsuit. But they buried me in motions and legal fees. I went bankrupt. I had to drop the case. Lost everything. I'm so sorry. Don't be sorry. Be angry. That's what I am. I'm furious. I have nothing left to lose. If you're fighting them, I'll help however I can. Finally, an ally. Over the next few days, I worked on documenting the pattern. 3 former employees. All fired in similar circumstances. All humiliated with company-wide emails. All threatened into silence. It wasn't about one employee, it was about systematic intimidation. Diane eventually agreed to share her documents with me, though she was terrified. Tom still refused to get involved, but Sharon was all in. I called Gary Preston again. I found a pattern, I told him. MedSource has been doing this to multiple employees. I have 2 witnesses willing to testify. Gary was interested. If you can prove a pattern of behavior, that changes things. That could be evidence of hostile work environment, systematic civil rights violations. Let me review what you have. I sent him everything. He called me back the next day. This is good. If both women will testify, I'll take your case on contingency. But you need to understand, breaking an NDA could expose them to lawsuits. They'd be taking a huge risk. I spent the next week working with Diane and Sharon, preparing them for what might come. Diane was wavering. Sharon was solid. Then my phone rang. Unknown number. I answered. Lori Thompson? A woman's voice. Cold, familiar. Yes? This is Patricia Walsh. My blood ran cold. I know what you're trying to do, Patricia continued. I know you've been contacting former employees. I know you think you've found some kind of pattern. Let me be very clear. If Diane Foster or Sharon Ellis testify in your case, we will sue them both for breach of contract. We will destroy them financially, just like we're destroying you. How did you get this number? We have resources, Lori. We know everything you're doing. Every email you send, every call you make. We're always watching. That's illegal. She laughed. Prove it. Here's my offer. Drop your counterclaims. We'll drop ours. You can walk away and start over somewhere else. Keep fighting. And you'll lose everything. And you'll drag those women down with you. She hung up. I immediately called Diane to warn her. She was crying when she answered. I got a letter today. From MedSource's lawyers. They're threatening to sue me if I testify. They know, Lori. They know I've been helping you. Diane, I'm so sorry. I can't do this. I have kids. I can't risk it. I'm sorry. She hung up. I called Sharon. They threatened Diane. They're going to threaten you too. Let them, Sharon said. I already lost everything. What else can they take? But one witness wasn't enough. Gary told me the case was too weak now. He couldn't take it on contingency. The trial was 2 weeks away. I sat in Natalie's apartment, staring at my laptop, looking at settlement papers Donald Pierce had emailed me. All I had to do was sign. Admit I was wrong. Pay money I didn't have. Promise never to speak about any of this again. I thought about settling, about giving up, about letting MedSource win. Then my laptop chimed with a new email. The sender was anonymous. The subject line said, I can help. The message was brief. I worked at MedSource. I know what they did to you. I know what Patricia Walsh has been doing. I have proof. Meet me tomorrow, 2 p.m., at the coffee shop on 5th Street. Come alone. I'll find you. I stared at the email, my heart pounding. It could be a trap. It could be MedSource setting me up. But it could also be the help I desperately needed. I wrote back, I'll be there. The next day, I arrived at the coffee shop 30 minutes early. I chose a table in the back corner where I could see the door. Every person who walked in made my heart race. Was this them? Was this the person who'd emailed me? At 2 o'clock exactly, a woman in her 50s approached my table. She was dressed professionally, with graying hair pulled back in a neat bun. She looked tired but determined. "Lori?" she asked quietly. "Yes, I'm Helen Crawford. I work in MedSource's IT department. Can I sit?" I nodded. She sat down carefully, placing her purse on the table between us. "How do I know this isn't a trap?" I asked. Helen reached into her purse and pulled out a USB drive. "Because I have this." "What is it?" 3 years of documentation. Emails. Internal memos. Recorded meetings. I've been watching Patricia Walsh destroy employees for 3 years. I've been collecting evidence the whole time. My hands were shaking. Why? Because I watched her do this to my best friend, Sarah. She left work early for a medical appointment. Patricia sent one of those emails. Sarah couldn't find another job. She lost her house. Last I heard, she moved to Arizona to live with her sister. I swore I'd find a way to stop Patricia. But I was too scared to come forward. Until now. What changed? You did. Everyone else Patricia targeted just disappeared. They signed NDAs and ran away. But you're fighting back. You're the first person who's pushed this far. When I saw you'd found Diane and Sharon, I knew it was time. Helen showed me the contents of the USB drive on her laptop. Email chains between Patricia and Brad, showing them deliberately losing documentation of jury summons. Internal HR memos discussing strategies to manage out problematic employees. A spreadsheet Patricia had created tracking what she called high-risk personnel. My name was on that list. It had been added 2 months before I was fired. Next to my name was a note. Close ties with Quality Control Department. Potential whistleblower risk regarding financial discrepancies. "What does that mean?" I asked. Helen explained. "You worked in financial analysis, right? You had access to Medicare billing records. MedSource was worried you might notice the fraud, the overbilling, the duplicate claims. They decided to get rid of you before you became a problem. The jury duty was just an excuse." Exactly. They were looking for any reason to fire you. When you left 2 minutes early, they jumped on it. Helen's documentation showed 11 other employees who'd been fired using similar tactics. All of them had been targeted with humiliating company-wide emails. All of them had their professional reputations destroyed. It was a systematic pattern of intimidation. "Why are you coming forward now?" I asked. "Because you're the first person who might actually win. With this evidence, you can prove what Patricia's been doing. You can stop her. But you'll lose everything. Your job, your pension." Helen's eyes filled with tears. "I've worked at MedSource for 15 years. I'm 3 years from retirement. But I can't keep watching this happen. I can't keep being silent." We talked for 2 hours. Helen agreed to be an anonymous source. She'd provide the documents but wouldn't testify in court. She was too afraid of the consequences. I understood. I thanked her and took the USB drive. That evening, I contacted Gary Preston. He reviewed the files remotely, and I could hear the excitement in his voice. "This is incredible. This proves everything. Deliberate targeting, systematic violations, conspiracy to terminate employees illegally. Lori, this is a smoking gun. Helen won't testify. She wants to remain anonymous. That's a problem. Without a witness to authenticate the documents, the defense can challenge their validity. But combined with Sharon's testimony and the pattern evidence, we might have enough." Gary agreed to take the case. He'd represent me on contingency, with the understanding that we were now potentially fighting for a class action. All 11 employees could be part of a larger lawsuit. The potential damages were in the millions. For the first time in months, I felt hope. 2 days later, Helen emailed me. "We need to meet." Something happened. We met at the same coffee shop. Helen looked terrified. Her hands were shaking as she held her coffee cup. "What's wrong?" "Patricia called me into her office yesterday. She said there's been a security audit. They noticed I accessed old HR files without proper authorization. She didn't directly accuse me of anything, but the message was clear. They know. Do they know you copied the files? I don't know. But Patricia said that unauthorized access to confidential records is grounds for immediate termination and potential criminal charges. She was threatening me, Lori. Without actually threatening me. What do you want to do? Helen was crying now. I have a disabled husband. I'm the only income we have. If I lose my job, we lose everything. Our house. His medical care. Everything. I understand. I can't testify. I thought I could, but I can't. I'm so sorry. I reached across the table and took her hand. You've already done more than anyone could ask. You gave me the documents. That's enough. But without me to verify them, will they even be admissible? I don't know. But we'll figure it out. Helen wrote a brief statement, carefully worded to avoid directly admitting she'd accessed the files. It was vague, but it was something. She was too terrified to do more. I took what I had to Gary. He reviewed everything and sighed. Anonymous documents are risky. The defense will challenge their authenticity. They'll claim you fabricated them. But with Sharon's testimony and the pattern evidence, we have a fighting chance. It's not perfect, but it's better than nothing. Trial was 1 week away. Gary filed an emergency motion to amend my countersuit to include allegations of systematic civil rights violations, hostile work environment, and conspiracy to terminate employees. He requested a delay to allow for proper discovery of class action claims. MedSource's legal team responded within 24 hours. Donald Pierce filed an opposition arguing that my new allegations were a desperate attempt to confuse the jury and that the anonymous documents were obvious fabrications. The judge scheduled an emergency hearing. Gary presented the USB drive evidence. Donald demanded to know the source. Gary refused, citing whistleblower protections. Without a named source, Your Honor, this evidence is inadmissible hearsay, Donald argued. The defense has no way to verify its authenticity or cross-examine its creator. The judge was torn. The evidence was compelling but procedurally questionable. The trial will proceed as scheduled, the judge ruled. The pattern evidence may be introduced, but without a witness to authenticate these documents, the jury will be instructed to give them limited weight. The defense may challenge their authenticity. It was better than nothing, but it wasn't the victory I'd hoped for. After the hearing, Donald approached me and Gary in the hallway. Last chance, Miss Thompson. Drop all claims. We drop ours. You pay nothing. You sign an NDA. Walk away. And if I don't? Donald smiled. At trial, we'll destroy your whistleblower. We know who she is, and we'll make sure the jury knows you convinced her to steal confidential documents. That's a crime, by the way. Computer fraud. She could face federal charges. My stomach dropped. They knew about Helen. Gary put his hand on my arm. Don't respond. Let's go. In the parking garage, Gary said, You should consider the settlement. If they're threatening your source with criminal charges, that's serious. It could work. If I settle, Patricia keeps doing this to other people. Forever. I know. But you have to decide if this is worth the risk. That night, I called Helen to warn her. She answered on the first ring. They know, she said immediately. I got a suspension notice today. Pending investigation into data breach. Lori, they're going to fire me. They might even press charges. I'm so sorry. This is my fault. No. Helen's voice was firm despite her fear. I chose to do this. I'm just not brave enough to see it through. Maybe you should settle. This isn't worth you losing everything. It's not worth me losing everything. After we hung up, I sat in Natalie's living room, weighing my options. Settle, and let MedSource continue destroying people, or fight and risk Helen going to prison. I thought about Diane, who was too scared to help, about Tom, who wanted to forget, about Sharon, who'd already lost everything, about the 8 other employees whose names were on Patricia's list, about all the future employees who would be targeted if no one stopped this. Morning came. Trial started in 3 days. I called Gary. Tell them we reject the settlement. We're going to trial. The courtroom was smaller than I expected. Wood paneling on the walls, fluorescent lights that hummed faintly. 12 jurors sat in the box, their faces neutral and watchful. Day 1 of the trial. Donald Pierce stood at the plaintiff's table with his 2 associates, looking calm and confident. They presented MedSource's case first, painting me as a problematic employee who couldn't follow rules. Timecard records showed my unauthorized departures. Performance reviews that had somehow become negative over the past few months were presented as evidence of declining work quality. Patricia Walsh and Roger both testified, describing my supposed threatening behavior when I'd allegedly confronted them in the office. Brad Hennigan took the stand and testified that I'd never informed him about jury duty. He was calm, professional, and convincing. The jury listened carefully. By the end of day 1, I felt sick. MedSource's case seemed airtight. Day 2 was our turn. Gary called Sharon Ellis to the stand first. She described her experience. How she'd left early to vote. How Patricia sent the humiliating company-wide email. How her career was destroyed overnight. Donald objected repeatedly. This is irrelevant to Miss Thompson's case, Your Honor. The judge allowed limited testimony about the pattern but instructed the jury to focus on my specific situation. Gary introduced Helen's USB drive evidence. Donald immediately challenged it. Your Honor, these documents have no verified source. They could be fabricated. Without a witness to authenticate them, they're inadmissible hearsay. The judge admitted the documents but instructed the jury to give them limited weight, since their authenticity couldn't be verified. Then I testified. I explained everything. The jury duty. The summons I'd submitted. The 2 minutes. The humiliating email. The systematic destruction of my career. Donald's cross-examination was brutal. He made me look emotional, vindictive, irrational. He suggested I was lying about submitting the jury summons. He painted me as someone who couldn't accept responsibility for my own failures. After 2 days of testimony, Gary pulled me aside during a recess. The jury seems sympathetic, but we don't have hard proof. It's your word against theirs. The pattern evidence helps, but without Helen to authenticate those documents, it's weak. Natalie squeezed my hand. You did your best. Day 3, Gary made a bold decision. He called Patricia Walsh as a hostile witness. Patricia walked to the stand looking composed and professional. She answered Gary's initial questions with practiced ease, describing MedSource's meticulous HR systems and procedures. So if an employee submitted a jury summons, you'd have a record of it? Gary asked. Absolutely. We maintain both physical and digital records. There would be documentation. And you have no record of Miss Thompson submitting such documentation? Correct. We have no such record. Gary introduced the Federal Jury Protection Statute. Are you familiar with Title 28? United States Code? Section 1875? Yes. It protects employees from retaliation for jury service. Are you aware it's a federal crime to intimidate or retaliate against someone for jury service? I'm aware, which is precisely why we didn't do that. Yet you sent a company-wide email with Miss Thompson's photo stating she was fired for leaving early. On the same day, she was required to attend jury duty. She was fired for a pattern of policy violations, not for jury service. Gary pulled up a timeline on a screen, showing all of my supposed violations. Interesting. All of these violations occurred after Miss Thompson submitted her jury summons to your office. That's coincidental. Gary then displayed the spreadsheet from Helen's USB drive, the one showing me flagged as a potential whistleblower risk. Have you seen this document before? Patricia hesitated. I'm not sure. I review many documents. This spreadsheet was created on your computer, Miss Walsh. Under your login credentials, it lists Miss Thompson as a high-risk employee 2 months before she was fired. Can you explain that? That appears to be fabricated. Would you like to examine the metadata? I'd need to see the original file on our servers. Gary requested the judge order MedSource to produce the original file. Donald objected, claiming attorney-client privilege. But the judge ordered the file produced for in-camera review. Court recessed for the day. That night, something unexpected happened. My laptop chimed with an email from Helen. "I've been suspended anyway. I'm going to lose my job no matter what. I can't let them win. I'll testify. I'll authenticate everything. I have nothing left to lose anymore." I called her immediately. "Helen, are you sure? I've spent 3 years being afraid. I'm done. Let them sue me. Let them press charges. At least I'll be able to look at myself in the mirror." I told Gary. He prepared a last-minute motion to add Helen as a witness. Day 4 of trial. The judge announced that the file on MedSource's servers was authentic. It matched the exhibit from the USB drive exactly. The metadata confirmed it was created under Patricia Walsh's login, dated exactly 2 months before my termination. Patricia was recalled to the stand. Gary confronted her with the proof. "This document is real, Miss Walsh. It exists on your company's servers. You created it. You flagged Miss Thompson as a problem employee before any policy violations occurred." "Why?" Patricia tried to backtrack. "It's just notes. Internal tracking. It doesn't mean anything. It shows you targeted my client before she did anything wrong. You were looking for an excuse to fire her. We monitor employees who might cause problems. That's standard risk management. Problems like reporting illegal activity?" Donald objected. The judge overruled. "Miss Walsh, did you know Miss Thompson was serving on a grand jury investigating MedSource for Medicare fraud?" "No, I didn't know that. But you knew she had access to financial records that might reveal fraudulent billing practices." "I didn't know about any fraud. That's not what I asked. I asked if you were concerned about what she might discover." Patricia was getting flustered. "We had concerns that she might misinterpret certain data. So you fired her to prevent her from misinterpreting data that might expose illegal activity?" Patricia realized her mistake too late. "No, that's not what I meant. I meant that we were concerned about. But the damage was done. She'd admitted that they'd targeted me to prevent me from discovering something." Gary pressed forward. "How many other employees have you fired using this exact same method? Humiliating company-wide emails? Destroying their reputations?" Patricia tried to deny it. Gary introduced Helen's documentation showing 11 separate cases. The jury saw the pattern clearly. "Patricia, you've been systematically destroying employees who might expose problems at MedSource, haven't you?" "I was protecting the company." Patricia's composure finally cracked. "That's my job. I protect the company from people who might cause legal problems or regulatory issues. That's what I'm supposed to do." The courtroom went silent. She'd just admitted everything. The judge called a recess. I saw Donald in heated conversation with a man I recognized from photos online. Charles Whitmore, the CEO, had shown up in court. When we reconvened, Donald requested to approach the bench. After a private conference, he announced, "Your Honor, MedSource would like to request a settlement conference." The judge ordered both parties to mediation. The mediation lasted 6 hours. MedSource initially offered to drop all charges against me if I dropped mine, and signed an NDA. Gary countered aggressively. He wanted $1 million, a public apology, and reinstatement of all 11 fired employees with back pay. The negotiations were tense. Donald kept trying to minimize the damage. But Gary held firm. He had Patricia's admission on record. He had Helen's documentation. He had the pattern evidence. MedSource was facing potential criminal charges if the FBI reopened their investigation based on Patricia's testimony. The final settlement. $750,000 to me. My record completely cleared. MedSource would issue a correction email to all employees retracting the original termination notice. They would establish a compensation fund for the other 10 employees who'd been similarly targeted. And no NDA. I could talk about what happened. MedSource released a statement admitting to procedural errors in certain termination cases, without admitting broader fault. I signed the agreement with shaking hands. That evening, news broke. The FBI had reopened its investigation into MedSource based on testimony from the trial. Patricia Walsh's admission about protecting the company from people who might discover illegal activity had triggered new scrutiny. 2 weeks later, Patricia Walsh was fired for cause. 1 month later, federal charges were filed against 3 MedSource executives for Medicare fraud and witness intimidation. Charles Whitmore was named in the indictment. 3 months after the trial, I'd paid off all my debts. I'd used part of the settlement to help Sharon and Diane start fresh. Sharon went back to school for a nursing degree. Diane moved back to the area and found a job at a different company. With my recommendation, Helen found a new position at a healthcare software company. I wrote her a glowing reference letter. She sent me a thank you card that made me cry. Trevor tried to contact me. He left voicemails apologizing, saying he'd made a mistake, asking if we could talk. I never responded. That part of my life was over. I started a nonprofit organization called the Employee Protection Foundation. We help workers fight wrongful termination cases. We provide legal resources, connect people with attorneys, and advocate for stronger whistleblower protections. The foundation is funded by my settlement and growing every day. Agent Kovac sent me a handwritten note. Thank you for not giving up. Sometimes justice needs someone brave enough to push it forward. 6 months after everything ended, I was invited to speak at a workers' rights conference. I stood in front of 200 people and told my story. About the email. About the destruction. About the fight. They count on you being too tired, too scared, too broke to fight back, I told the audience. They count on you giving up because the system seems too big, too powerful, too rigged against you. But the moment you refuse to be silent, the moment you stand up and say, no, this isn't right, you become dangerous to them. And that's when you've already won. Because you've proven that one person with truth and courage can challenge an entire corrupt system. The audience stood and applauded. Afterwards, dozens of people came up to me. They told me their stories. They asked for help. They thanked me for fighting. I've learned that justice isn't something that just happens. It's something you have to fight for. It's exhausting. It's terrifying. You'll lose things along the way, but the alternative is letting people like Patricia Walsh destroy lives without consequence. The alternative is letting corruption and intimidation win. I still have hard days. Days when I remember how close I came to giving up. How close I came to signing that NDA and disappearing like all the others. But I didn't give up. And because I didn't, 11 other people got justice too. And maybe, just maybe, the next person who gets targeted by a corrupt HR department will remember my story and find the courage to fight back. That's worth everything I went through. Now I want to hear from you. Have you ever faced workplace retaliation or wrongful termination? Have you ever felt powerless against a company or system that seemed too big to fight? What would you do in my situation? Share your thoughts in the comments below. Your story matters, and you never know who might need to hear it. If this story moved you or made you think, please hit that like button. Subscribe to hear more stories about people who fought back against injustice and won. And share this video with someone who needs to hear that they're not alone, that fighting back is possible, and that truth and courage can overcome even the most powerful opposition. Thank you for listening to my story. I hope it reminds you that you're stronger than you think, that justice is worth fighting for, and that no system is too big to challenge when you have the truth on your side. Stay strong, stay brave, and never let anyone silence you.